Justice Lenaola. Now I give this chance to Honorable Justice Wanjala to read the judgment on issues number 3 and 4. Justice Wanjala.
Thank you, Chief Justice. The issue number 3, what is the legal effect of the withdrawal of a presidential election candidate before an election? Did any of the candidates validly or properly withdraw from the presidential election held on 26th October 2017? Now, the attribution of illegality to IEBC's retention of the Honorable Raila Odinga's name on the ballot after he wrote a letter withdrawing his candidature was a subject of submissions by all the petitioners. In response, the first and second respondents relied on Regulation 52 of the Elections General Regulations 2012, submitting that save for a withdrawal by a candidate in any election 3 days after nominations, the election laws do not contemplate any withdrawal. And consequently, the Honorable Raila Odinga's letter of withdrawal as a presidential election candidate amounted to just a mere intention to withdraw with no legal effect, as it had not been communicated via the prescribed form. Now, the question calls for an answer. What is the effect of the alleged withdrawal by the presidential candidate? This entails interpretation of the Constitution and the applicable laws, as well as, again, the effect of the Raila 2013 in that context. We note that neither the Constitution nor the Elections Act makes provision for the withdrawal of a candidate from an election. The procedure for withdrawal of a candidature is instead provided for under Regulation 52 of the Elections General Regulations 2017. And we have cited the provision. It is thus under the law plain that a presidential candidate who intends to withdraw can only do so within 3 days of the nominations by filling the prescribed Form 24A and submitting the same to the returning officer, in this case the first respondent. It was the petitioner's standpoint, however, that Regulation 52 is not applicable to a fresh election because no nominations had been conducted prior to that election. They urged the court to rely on Raila 2013 for guidance on the issue. In that decision, this court held that if a candidate who took part in an original presidential election abandons a fresh election scheduled under Article 140 of the Constitution, the provisions of Article 1388B would become applicable, with fresh nominations ensuing. In determining the legal effect of withdrawal by a candidate before an election, what guidance, therefore, can be drawn from the pronouncements of this court in Raila 2013? And the operative paragraphs are 289 to 290, and where the court stated, and we have already cited those statements by the court, by that bench on 2013. These 2 paragraphs have assumed judicial prominence since the nullification of the presidential election of 8th August 2017 by this court. Not only have they been subject to contradictory interpretations by parties to the petitions before us, they have also elicited varying, in quotes, expert comment from many quarters. In the High Court before Mativo J, the question arose as to whether the Supreme Court pronouncements constituted ratio decidendi and were therefore binding on him, or whether they were obiter dicta. The situation is even more complex as the Ekuru Court case is now on appeal, pending determination before the Court of Appeal. This is significant in view of this court's general policy of staying its hand in a matter that is pending before another superior court. The relevance of such questions in this instance calls for a consideration of the point whether the above paragraphs in Raila 2013 are of binding authority. The second question is whether this court should, notwithstanding the fact that the matter is pending on appeal, proceed to determine this issue. And the third question is whether it is necessary for the court to make a clarification of the meaning of the said paragraphs in view of the contradictory interpretations attendant upon them. To the first question, it is not in doubt that in making some of the pronouncements it made, the Supreme Court then was responding to hypothetical questions that had been expressed before it by the Attorney General in his capacity as amicus curiae. The questions were not essential for the determination of the two petitions before the court, and the answers to them could not therefore constitute the ratio decidendi of Raila 2013. To that extent, therefore, the pronouncements in those and other related paragraphs were obiter dicta and thus not binding on other courts. Mr. Justice Mativo, in his carefully thought-out judgment in Ekuru Court, is not therefore to be faulted for having characterized the said statements as such. As to whether this court should determine this matter while it's pending on appeal, it is apparent to us that this is no ordinary matter, resolution of which can await the appellate process. The petitions now before us could stand or fall on the basis of how we determine the twin issues of withdrawal of candidature and nominations, as the Supreme Court in this instance is exercising its original and exclusive jurisdiction under Article 140 of the Constitution. An abnegation of its task is not tenable, and the responsibility devolves to it to resolve the relevant questions without reservation. The court's task is to determine this presidential election petition. To the third question, in ordinary circumstances, having declared paragraphs 286 to 290 of the Raila 2013 decision obiter dicta, there would be no need to clarify their meaning, since they are of no binding effect. However, though obiter, these pronouncements hold special stature, emanating as they do from the apex court. It is proper, in the circumstances, to consider the content of paragraphs 289 and 290 as the suppositions today have a live face before us. Paragraph 289 therefore reads, it is clear that a fresh election under Article 143 is triggered by the invalidation of the election of the declared president-elect by the Supreme Court following a successful petition against such election. Since such a fresh election is built on the foundations of the invalidated election, it can, in our view, only involve candidates who participated in the original election. Thus far, it is clear to us that the foregoing statement represents the correct legal position. But the paragraph also reads, in that case, there will be no basis for a fresh nomination of candidates for the resultant electoral contest. The foregoing statement is only correct to the extent that it refers to the nullification of an election of the president-elect where the issue of nomination of candidates was not the basis for the nullification of the election. If the petitions before us, in the petitions before us, the nomination of candidates was not the basis for the nullification of the election of 8th August 2017. But if an election is nullified on the basis of flawed nominations, it is clear that the ensuing fresh election cannot be conducted on the basis of the same flawed nominations. Fresh nominations would, in the circumstances, have to be conducted. Coming to paragraph 290, which appears more conjectural, the paragraph reads, suppose, however, that the candidates or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date, then the provisions of Article 1388B would become applicable with fresh nominations ensuing. It is clear to us, with the benefit of hindsight, that had the foregoing pronouncement not been made obiter, had it been a ratio, it would have been made per incurium, since Article 1388B of the Constitution only contemplates 3 scenarios of a cancellation of an election. and we have set out what these three scenarios are. Withdrawal of one candidate from the electoral contest is clearly not one of the scenarios contemplated by Article 1388B as a basis for the cancellation of an election. In the circumstances, this court would have had to depart from that decision, the decision in question. Our immediate question, therefore, is, did the presidential candidate for NASA withdraw from the 26th October 2017 electoral contest? It has been submitted by the respondents that because he did not effect his withdrawal by the prescribed Statute Reform 24, the Honorable Raila Odinga's purported, in quotes, withdrawal was of no legal effect. On the other hand, the petitioners urged that the withdrawal was effective as it was notified through a letter, and that Regulation 52 was inapplicable to this particular case. It is clear in the above context that Regulation 52 provides for withdrawal for candidate within 3 days of the nominations. The said regulation is clearly not applicable to the situation at hand. The nominations had long been conducted before the scheduled fresh election. Does this mean that after expiry of the 3-day period, no candidate can withdraw from an election? We don't think so, as one cannot be forced to participate in an election in which he or she has lost interest. The NASA candidate, in our view, not only made a public announcement of his decision to withdraw from the elections, but addressed a formal letter to that effect to the first respondent. Such action, in our perception, constituted a substantive and legally effective withdrawal from the elections. What legal effect, therefore, did the withdrawal of the NASA candidate have on the 26th October